We do have one of the members who is still on Donald Trump's team. His name is Jim Trusty, and he joins us now. Jim Trusty, thank you for being here. Let's get right into it. As President of the United States, did Donald Trump know how the declassification process worked, or did he just ignore it?
Well, President Trump was exactly right in your town hall the other day. He is aware of a bureaucratic process that can be used. He used that bureaucratic process in the middle of his presidency to declassify the Crossfire hurricane matters that are the subject of that 316-page report we saw this week. But at the end of his presidency, he relied on the constitutional authority as commander-in-chief, which is to take documents and take them to Mar-a-Lago while still president, as he was at the time, and to effectively declassify and personalize them. He talked about declassifying them, but he didn't need to. And if you look at the Constitution, you look at the Presidential Records Act, there is absolutely no basis for saying that bureaucracy rules and the president doesn't have the authority entrusted in him by the voters to possess and to declassify and to hold on to documents.
Hold on. Let's look at the Presidential Records Act and what it actually says. It says the United States shall reserve and retain complete ownership, possession, and control of presidential records. And under federal law, willfully removing any record or document carries the possibility of a 3-year prison sentence. We looked it up, as journalists do, and you know, nowhere does it say that you can mentally just think about it and that they are declassified. So you haven't heard this from any other president at any other time. So what gives Donald Trump the right to use mental gymnastics to try and figure this out and try to put out there that this was all perfectly legal?
You've packed so many misstatements into one question or whatever that was. I'm not sure. But let me tell you this.
Well, I read the law, so it's not a misstatement.
The Presidential Record Act. Well, we'll see about that. The Presidential Record Act does not have a criminal enforcement component to itself, okay? Look at it again, not in the PRA. PRA says that presidents and archivists have to try to work together to resolve the universe of documents that are held onto by the former president or turned over to the archivist. The universe there is literally personal or presidential. And the case law has shown in every case but President Trump's that NARA and the DOJ completely defer to the former president's decisions as to which documents he's going to hold on to or which ones he's not. Bill Clinton had audio tapes of hours and hours and hours of recordings from the Oval Office. When NARA was sued, and by the way, that's the remedy under the Presidential Records Act, is civil litigation. When NARA was sued, DOJ stood there in open court and said, Judge, none of us may like it, but the president gets to make that determination. If NARA doesn't like his determination, they can sue. Sock drawer Bill Clinton, his tapes were fine. Obama, 2018, there's a letter from the Obama Foundation acknowledging millions of documents in a former furniture store in Illinois, including classified documents. And their remedy to any situation there in that totally unsecure setting is to say, you know what, we're going to give you $3.3 million, NARA, to help transport these documents whenever we digitize the library. Now, it's been 5 years. There's no hint of a digital library yet. But none of this is criminal. None of it has historically ever been subject to criminal tools such as subpoenas or search warrants. But for Donald Trump, there's an exception that this DOJ and this FBI are pursuing to mislead the American public, to misuse statutes that are not criminal, and to have an ends justify the means mentality when it comes to one president only.
The statute I read talked about the fact that there could be a 3-year prison term. And I do want to remind you that you talked about, you know, the different presidents going and saying, hey, we have this, we will send it to you. The issue here, the archive has said, is that they asked for the documents repeatedly over and over and over again over many months. And at first we're told that they didn't have them, and then they just wouldn't turn them over. And that is the difference between those people who had some of the documents and Donald Trump. So do you see nothing wrong with what Donald Trump did?
Absolutely nothing criminally wrong. If they wanted to sue and they wanted to speed up the fight, they could do that. But he engaged in negotiations. You're glossing over the fact that in January of 2022, he gave 15 boxes worth of material to archives. I've looked at every one of those
Right,
boxes.
but after they asked
provided
for
that
it
to them.
over and over and over
Well, let me
again.
finish, please. It took Nixon 13 years to get his tapes to archives, okay? Bill Clinton got to hold on to the sock drawer tapes. Obama, NARA, the politicized bureaucrats that they are, announced that, don't worry, we have everything from Obama. And then Delaware laid bare the truth that they didn't have everything from the Obama administration. And frankly, I'm sure they still don't. So every president and many people that don't even have the power of declassification have held on to documents for years and years and years, hopefully, usually innocuously, or even unknowingly, and that is not a criminal prosecution until we get to today.
They can hold on, but they can have some of the documents that are not. We are talking about classified documents. Classified documents that could have
and the
huge
presidential
impacts.
records that you can.
So let me just wait. Let me just quickly ask you. Let me quickly ask you. In the letter
Okay, well,
that
if you want to just, if you want to make speeches, make speeches.
I'm not making a speech, sir. I let you speak for quite some time. And in the letter that you and your fellow attorneys sent to Congress, you made it a point to not opine, as you put it, about whether the documents were classified. Why not, if, as you say, that your client was doing a, quote, standing order that documents removed from the Oval Office were automatically declassified?
That document was designed to make a very specific point. What we said is DOJ refuses to show us the affidavit. DOJ refuses to show us the documents, despite me having clearance to review them. We have no way of knowing whether any of these documents, even by their own terms, would be considered classified, much less declassified by the president. The point was to say to Congress in a nonpartisan way, this is an overreach. We need to look at the system. Why all these different presidents and sometimes vice presidents and congresspeople are having classified documents in their possession. It doesn't translate into a crime, no matter what the underlying facts are. And so the point of that letter was not to give a full-throated defense of everything we could say at trial, which is numerous types of defenses and numerous moments of overreaching by DOJ, but to point out that a congressional fix, an ODNI-based fix, is the way to go here.
You also signed a letter arguing the former president didn't know what was in the boxes, but here's what he told Caitlin Collins.
When we left Washington, we had the boxes lined up on the sidewalk outside for everybody. People are taking pictures of them. Everybody knew we were taking those boxes. And the GSA, the government service, the GSA was the one taking them. They brought them down to Mar-a-Lago.
So you signed this letter, and Donald Trump now says this. Who's lying here?
Nobody's lying here. Nice try. That's like, when did you stop beating your wife? But the bottom line is, President Trump didn't sit there and fold up documents and newspapers and pictures of Celine Dion and put them into boxes for transport. There was a whole bunch of people that worked at the White House, that helped with the White House, that packed up materials and sent them to Mar-a-Lago while he was still president. So we're not going to sit here and pretend that President Trump personally looked at every single box. He knows the general nature that there are golf shirts and there are golf scoring cards and that there are pictures of Celine Dion. He knows from the unprecedented and unwarranted and unconstitutional search of Mar-a-Lago that they took things like passports that had nothing to do with anything, tax records, medical records. This was a fishing expedition by prosecutors who were engaged in persecution, not following evidence, but criminalizing a non-criminal dispute. And if we let this genie out of the bottle, it's going to come back to haunt generations, where we don't have executive privilege, we don't have attorney-client privilege, where we create new rules for Donald Trump because people in power and people in federal law enforcement want to go after him. So that's the message of our letter. That's the message. Well, go ahead.
That you were sending to Congress. So I guess the question is, why should a president, no president is above the law, no one in this country is supposed to be above the law. So why is he able to just ignore a subpoena? Should that be okay?
He didn't ignore subpoenas. We talked about the 15 boxes. We talked about the fact that in every other case in history, it is a long, drawn-out process of negotiation. That probably explains the patience NARA had with the 2018 letter from Obama that said we have millions of documents, including classified ones. You'll get them eventually.
Asked for the boxes. They came back to find 15 more boxes, and so they did not pay attention to the subpoena. So why is that okay, is what I'm asking. If I did that as a citizen, there'd be hell to pay.
Well, you also don't have the powers under the Presidential Records Act or declassification, and I'm pretty sure you're not, not president right now. But let me just say this. You are ignoring the fact that for the first time in history, a weaponized DOJ, much like the one described in the Durham report, with the same culture, maybe not always the same individuals, they decided to use the Presidential Records Act as a Trojan horse. Get inside Mar-a-Lago, pretend that there's some problem there. By the way, the last time the president had contact with DOJ before that subpoena, he said, attorney, show them where this stuff is in the storage room. The attorney did that. And he said to the official that has led much of the charge here, the trophy hunt, if you need anything else, just ask. He was in a negotiating stance from the beginning through the end. They said, put a lock on that door, and then they were the first ones to go quiet and break the lock 2 months later in an unprecedented raid. This is the only president that would face this type of ends justify the means behavior. And as one of his attorneys, we're going to fight it.
All right, Jim Trusty, the DOJ would have a very different story about that. The FBI certainly disputes what you just said, but I thank you for coming on. I appreciate your time.
Through their leaks, they certainly have, but thank you.